everybody, it's me, Hannah, with Solo Suit, and I am going to show you an interview that I recently had with a consumer rights attorney. In our interview, we go over some common questions that we receive at Solo Suit about debt settlement, how to respond to debt collectors in court, and bankruptcy. So if you've ever asked yourself, what is a junk debt buyer? How do I respond to a debt collection lawsuit? What is the best defense in a debt case? How do I settle my debt? How much should I offer to settle? If you've ever asked yourself any of these questions, we go over them in this video, including more questions, and we hopefully can help you find some answers that will point you in the right direction to responding to debt collectors and resolving your debt once and for all. So stay tuned.
Awesome. Well, thank you so much, John, for being willing to join our YouTube channel today and talk a little bit about how consumers can deal with debt collectors, especially if they've been sued. Do you want to give us a little introduction to who you are and what you do?
Yeah, absolutely. No, I'm glad to be here. So I'm an attorney in the state of Arizona. I represent people who are dealing with what you're talking about, who've been sued by debt collectors, and I also do consumer bankruptcy. And that's actually how I got involved in defending consumers, is I was having so many people that were thinking, hey, I need to file bankruptcy, when really they were just dealing with this one debt collection lawsuit. And so I started defending those about 20 years ago and found that there were some pretty good defenses and ways to resolve it. So not only that kind of led into, I have a YouTube channel as well. It's called the Consumer Warrior YouTube channel, where I put up a lot of videos similar to what we're doing here, what kind of tips and strategies to helping people who are dealing with some pretty serious debt issues. So that's kind of what I do all day long. So.
Cool. So you said you have how many years of experience in this sphere?
I've been practicing law a little over, I guess it's been about 21 years. And so I've been doing bankruptcy that whole time. And then I got into what I call debt defense, defending these type of collection suits probably about 15 years ago.
Cool. And I'm just curious, what got you into that practice? Was it you wanted to help people, or how did you end up choosing this particular side of law?
Yeah, I always say it's kind of funny. You never know what you're going to be doing. When you're a little kid, you don't sit around saying, hey, I think I'll be a bankruptcy attorney, or, that kind of thing. When I went to law school, I had a really great bankruptcy professor. He's actually one of the professors who wrote one of the big legal, treaties on bankruptcy. And he made something that was kind of a dry subject actually pretty interesting. So when I started my own law practice, which I started pretty quick, about 18 months after I got out of law school, I started my own practice. I started doing bankruptcy work, which I enjoyed. And then, like I said, so I did bankruptcy work. I was doing it probably 4 or 5 years. And I just saw this common thing over and over again, where people were coming into the office. They'd been sued by a debt collector, and more often a junk debt buyer. And, they were saying, okay, I guess I better just file bankruptcy. And it was this $5,000 lawsuit. $5,000 is $5,000, but I was like, gosh, they weren't dealing with anything else. And so I really kind of started diving into figuring out, are there defenses? Are there ways that we can try to resolve this? And as the more I dug into it, the more I started to realize, there's some real problems with the way the junk debt buying industry works in this country. And they get away with it most of the time because, nationwide, the statistics are over 95% of people end up with a default judgment because they just don't take the initial step of just filing a written answer. And so that's really how I got into that part of it, where, I started taking a lot of cases, helping people to avoid bankruptcy by dealing with the debt collection lawsuit. And so that makes up a full 50% of my practice now. 50% I do is here in Arizona is debt defense type work, and then the others, for other consumer bankruptcy type issues.
Well, that's awesome. I think what you do is super duper important work. I want to highlight something you mentioned about 95% of debt collection cases are lost. And I think a lot of the time it's because people just don't know where to start when they receive a notice that they're being sued. They just feel overwhelmed. They don't know how to answer. It's a pretty intimidating thing to go through. You also mentioned junk debt buyers. Can you tell us, what is a debt buyer? How does that work?
It's this industry, as large as it is, and as many people's lives that it impacts. It's surprising how few people know what junk debt buyers are, what they do, even amongst attorneys, and even amongst bankruptcy attorneys. Sometimes I'll talk to attorneys, I'm surprised they've never heard of it. But so the debt buying industry, essentially what they do is creditors, when an account goes into default, like a credit card, they have roughly 6 months to try to collect on it internally. After 180 days of no payments, they charge it off. And excuse me, the charge off, one of the most misunderstood components of this is the charge off is that most people don't realize when a debt is charged off, it's really just like an internal tax classification. The creditor can still continue to try to collect on it. But what most credit card companies do in the US is they package up all these charged off accounts and they sell them in a big portfolio to these companies. They don't call themselves junk debt buyers, but they're debt buyers. They go out and they buy these old charged off accounts and they buy them in gigantic volumes. You know, there's some really big players in the country. One of them, Encore Capital, Midland Funding, Portfolio Recovery Associates, LVNV Funding. A lot of people will see names like that. They buy these and they usually buy them for pennies on the dollar. There was a study done by the FTC a number of years ago with Encore Capital. They on average paid about 4 cents on the dollar. So they're buying these at a crazy discount, you know, for pennies on the dollar. And then they're alleging that they step into the shoes of that original creditor. And so then they go out and they file lawsuits just en masse. You know, they file, I think the one I saw with Encore Capital, they file on average about 500,000 lawsuits a year. That number might be old as well. They may even file more. Portfolio Recovery Associates, same thing. So what I see here in Arizona is in the justice court system that deals with accounts under $10,000. The junk debt buyer lawsuits, they're second only to like speeding tickets, you know, that kind of thing. I mean, the volume is gigantic that they file. If they file the lawsuit and if they get a judgment, and like we were saying, 95% is a default judgment because people don't respond to it. Then once they have that judgment, things change dramatically because now they can garnish bank accounts, they can garnish wages, they can lien your home, and they can cause all kinds of grief. Not only that, like in a state, like in Arizona where I practice, a civil judgment is good for 10 years, and it can be renewed every 10 years for the rest of your life. And so interest continues to accumulate. And so, you know, routinely in my practice, I see something that was a $2,500 judgment entered 20 years ago, and now it's $35,000, and you know, people are getting their wages garnished indefinitely, and then it does result in a bankruptcy. So, the debt buying industry, it's huge. They kind of fly under the radar a bit, you know, as far as people knowing who they are, what they do, till it's, you know, staring you in the face where you have to deal with this thing, with this debt collection lawsuit.
Wow, crazy. The craziest part to me is, like you said, they do kind of fly under the radar. Like a lot of people don't know who these people or who these companies are. Encore Capital Group, I think they own LVNV Funding and Midland Funding, right?
Yeah.
And they should be like household names because so many people are being sued for these types of cases, but they're not. Like I said before, no one really knows who they are. Thanks for describing what a debt buyer is to us. I have a couple questions about actually how to go about responding to a debt lawsuit. What do you think are some of the best defenses that you can use in a debt collection case to either get it dismissed or to reach a settlement?
The first thing you have to do is file a written answer in most situations, particularly if you're not sure what to do, if you don't know if you have the ability to offer a settlement, or maybe you don't have the ability to right now, but maybe you will. Filing an answer will help you to avoid the default judgment. And if you don't file the answer, which is just your written response to this, if you don't file that, the court will just give them everything they're asking for. And if they have attorneys, they can add attorney's fees, they can add interest on top of it. So filing the answer is the first thing you need to do. But a couple of things with filing an answer. I always say the answer is super important. It's generally probably the simplest stage of the lawsuit because it can be fairly straightforward. I know with solo suit, you guys have tools and things that can help people put it together. It has to be done correctly. And that's why I like tools like solo suit that can help you put it together, because I see, and we can maybe go into mistakes, but I see when people draft it themselves, the biggest mistake they put is they put way too much information in their answer. And it can actually harm you to do that. At the beginning stages, all the court wants to know is, is there an actual dispute? You know, you should view the lawsuit as, this is the junk debt buyer or the creditor, whoever it is, saying, hey, here's my allegations. And the court's basically saying, okay, Mr. Consumer, Mrs. Consumer, what do you say? You know, what's your response? Do you admit or deny what it is that they're alleging? And if you deny it, then the court's saying, okay, we have a dispute. That's what we're here to do. We're here to resolve the dispute. So filing an answer is the first thing that you need to do, whether you're going to focus on settlement, whether you're going to try to take the case to trial. The biggest defenses I see is that, particularly as it relates to junk debt buyers, and I kind of break these up into two categories. Original creditor lawsuits, often like American Express, they usually file their own stuff. Sometimes they'll sell it, but usually they file their own lawsuits. Or if you get sued by Portfolio Recovery Associates. I often treat those defenses differently. Original creditor suits are a little harder. They're quite a bit harder, unless there's like an identity theft issue to prevail on. But junk debt buyers, you've got to kind of get the bigger picture of what they're doing. When they go pay 4 cents on the dollar for these accounts, they don't get a whole lot in return. Often they get a spreadsheet. They might get one or two monthly statements. They get a spreadsheet with some, name, address, account number, that kind of thing, which in a default context ends up being okay, that's enough because nobody's fighting them on it. But when you contest it, they often don't have a lot of the documentation or the witnesses that they need to be able to establish their case. And so by filing an answer, all of a sudden now you put their feet to the fire, but that they've got to prove their case. I think that's one big kind of thing that people don't understand is that they're the plaintiff. The creditor has to prove all of the elements of their case. You don't have to disprove anything. LVNV sues you. You don't have to prove that you don't owe it. They have to prove not only that you had the original contract, but they've got to show that they received it and that they own it. And if they can't do that, the court shouldn't grant them a judgment. So there's many defenses related to the sufficiency of their documents, their witnesses. I've done over 400 trials against junk debt buyers. I've never once had an original creditor witness appear. But having the original creditor witness at a trial is super important, and they just don't have it. It's not in their contract to have these people fly in or even appear over the phone. So often pressing that issue as far as the sufficiency of their documentation, their witnesses, that can be a good defense. And then a lot of times we'll push cases into private arbitration. It's not really a defense, but it's an approach where they typically don't want to deal with the case in a private arbitration setting that's like outside of the court. I always say if you're going to ask the court to push it into private arbitration, it's something you need to be prepared to do. I do a number of those and they will follow you in sometimes, so you need to be prepared to do it. And then you also need to ask yourself, what do you consider winning the case? Air quotes, winning. Because sometimes settling the debt is a great way just to get this thing done, and it's a win. It can be done very quickly. I know Solo Suit has some products and a platform that can help you with settling the case that could make this thing go away quickly. I do tell people, if you're representing yourself and you get sued by a debt buyer and you're like, okay, I'm going to take it to trial, that's fine, but be prepared. This thing's going to be part of your life for the next 6 to 12 months at minimum. And it can take over your life. And you're at night researching it and watching YouTube videos with us and that kind of thing, trying to figure out how to figure this out. Sometimes settlement can be the quickest way, and it often is the quickest way to get it resolved, is by coming up with some type of plan to go in and offer something less than what it is that they're asking just to get it resolved. So those are kind of the main things. I know I'm kind of going on here, but that's kind of the main approach I take to these cases.
Yeah, so let me just recap. The best defense that you can use in a debt collection case is just to file an answer, because oftentimes junk debt buyers won't have the necessary documentation to prove their claims. At Solo Suit, we're not attorneys, so we can't give legal advice. And I know that you can't give legal advice either unless you're officially representing someone. But typically we've seen in our experience that it's best to deny as many claims as possible to force the junk debt buyer to prove their claims, right? And if they can't, then the case may be dismissed, or you might be able to have a better chance at settling. And you're right. Yes. At Solo Suit, we do offer documentation. We offer people a template that they can use to respond to a debt lawsuit. It's called our debt answer. Not only does it give people a chance to respond to each claim that's against them, but it also gives them an opportunity to assert their affirmative defenses. So I was wondering if you could weigh in on that. What is an affirmative defense, and what are some common affirmative defenses in debt collection cases?
Sure. And before I even get to the affirmative defenses, you brought up a point that I think is good. As far as, are you denying or are you admitting what it is that they're stating in their complaint? I always say this: when you approach anything that you submit to the court, you've got to make sure that what you're submitting is accurate. But I do say you need to be painfully accurate, in how you respond to it. If they're saying that you owe $5,316.23, and you don't have any independent knowledge as far as how they came to that exact number, it's okay to say, that you lack sufficient information. Or a big one I see is a lot of debt buyers, they put in their complaint, there'll be a paragraph saying, Midland Funding LLC purchased or was assigned an account held by Capital One. Unless you have independent knowledge that actually happened, it's okay to deny it or to say that you lack sufficient information. What you want to be careful of is if if they're saying, I live here in Maricopa County in Arizona, if they say John Skiba is a resident of Maricopa County, I'm not going to deny that if it's true. We need to be accurate on there because it also builds some credibility with the court. We just need to be very accurate. And often when people are filling out their answer, we tend to assume things, assume language into it, and you don't want to do that. You want to read the question or read the facts, what they're alleging, and then respond to it specifically to what they're alleging in the complaint, if that makes sense. When it gets to affirmative defenses, the easiest way to understand what they are in a civil context, so a debt collection lawsuit, this is just a civil matter. Nobody's going to jail or anything. The easiest way to do it, though, is in a criminal law context. So like an affirmative defense in the criminal world, let's say that somebody commits a murder. They could go in and say, yes, I did that, but I have an affirmative defense of self-defense or insanity or something like that, where they're saying, even if it is true, I killed this person, I do have a defense because they were trying to kill me. So it's my self-defense. So in the civil context, we have affirmative defenses as well, where you're essentially saying, even if everything that plaintiff creditor is saying is actually true, I have a defense. The biggest one that people use is statute of limitations. And this is something too I see that people misunderstand a lot. The statute of limitations is the amount of time that the law gives a creditor to sue you from the time that the account goes into default until they have, their deadline to file the lawsuit. So like in Arizona for credit cards, it's 6 years. It's different. It differs in each state, but it's usually somewhere around there. So from the time that the account goes into default, they have 6 years to file a lawsuit. If they file too late, if they wait too long, then there's an affirmative defense that you could raise of the statute of limitations, where essentially you're saying, look, even if everything that they're alleging against me is true, the statute of limitations is run, so this thing needs to be thrown out. I will also include in there, if I think that the case is subject to a private arbitration clause, I include that as an affirmative defense. It's kind of it doesn't fit perfectly, but what it does is it puts them on notice that, hey, I might invoke this private arbitration clause and get this thing taken out of court and have the American Arbitration Association deal with it instead of dealing with it in the court system. So those are the kinds of things you're going to look at. And in a lot, the reason why these are important, sometimes if you don't assert them in the answer, they can be considered waived. So really you're just putting, even if you're not sure that the statute of limitations has expired, I always include it. Even if I think that, hey, they're probably well within it, I'm still going to throw it out there just in case down the road they provide me a document. I'm like, wait a minute, this is different than I thought. So that's what you're looking at as far as affirmative defenses go.
Awesome. So just to recap there then, in your answer, you don't want to give out too much information. And a lot of the time, consumers tend to just overshare when they make their own answer document. Yeah. But really, you just want to stick to the claims against you, respond to the claims, and then assert any affirmative defenses that might apply to your case, such as the statute of limitations. One really common question that we get at Solo Suit is about the service of the summons and complaint. So when a lawsuit is initiated, right, you receive the court documents, the summons and complaint usually is what they're called. Sometimes it's called a petition, I think, in some southern states. But anyway, you know this already. My question is, can you use like lack of service as an affirmative defense? We get that question a lot. What are your thoughts on that?
Service is a big problem in the debt collection world. I meet people almost every day I come to work who tell me, look, I have this judgment against me that was entered 3 years ago and I didn't even know about it. It's routine. And I think that service is, because service, and we should back up maybe a bit. So serving the complaint in the summons or the petition in the summons, in most jurisdictions, in most states, someone has to literally come by your house and knock on your door and put it in your hand kind of thing. And if they don't do that, then they can't go on and try to get a default against you. The idea being, look, they've got to give you notice of this. They've got to give you the opportunity to respond and file your answer. And so what we see, though, is that sometimes that first step is not taken correctly. They go to the wrong address. Don't think it happens a lot, but I've had process servers that frankly just weren't being truthful. They filed a document saying they served them, and we were able to prove with actual evidence that that didn't happen. And so I don't think that happens a lot, but I think that it does happen. The thing is, as far as lack of service, if they didn't do it correctly, in most jurisdictions, most judges that I've dealt with, if you file your answer, the issue's probably been waived, because essentially the court's saying, look, the whole purpose of service of process is to put you on notice. You clearly know about it because you filed an answer with the court. Or what I see is if you're alleging that service was defective, And I should say that this is before that, there's no judgment, there's no default, there's nothing like that. If you come in and say, hey, judge, they didn't serve me correctly, the judge will likely give them the opportunity and say, okay, go back and do it correctly, and then they can file their response. I get roughed up all the time on my YouTube channel in the comments when people tell me, you should try to dodge service and don't answer the door, peeking through the blinds, don't do. My approach is always just accept it. Just get service, get served with and then you can file the answer and deal with it head on. Because like I said, every single day in my law practice here in Arizona, I meet with people that didn't get served or were trying to dodge service. The court will allow them and give the creditor permission often to serve you in other ways, sometimes through the mail, sometimes via email, sometimes just taping it to your door. And people don't find out about it, and then they end up with the default because they didn't timely file their answer. So service it's a big issue, but generally, if you have actual notice of it, the court's either going to let them fix it if they did it wrong, or they're just going to say, well, it's waived. You filed your answer. Let's just move forward at that point.
Okay. Well, thank you for weighing in on that. We get that question a lot, so I wanted to get an attorney's advice or thoughts on it. So you mentioned that lack of service can result in a default judgment, or just not responding in general will often result in a default judgment.
Yeah.
And earlier you talked about how one of the consequences of default judgment is wage garnishment. Another consequence is getting liens put on your property, maybe even having your bank account frozen. I wanted to ask you some questions about wage garnishment. So can I just throw a few at you and maybe we can respond to them like rapid fire?
Sure.
First of all, do you know how much a creditor or debt collector can take out of your wages?
That's state specific. Here in Arizona, it used to be 25% of each check. In November 2022, they reduced it here down to 10% of each check. And that's 10% of your net, after they take the taxes out. Most states are going to be right around that. The federal government, when they do, sometimes they'll do garnishments for student loans, they're capped at 15%. I don't think I've seen anything over 25%, which was a huge chunk that Arizona used to do. And then a few states don't even have it. Like I know Texas doesn't have wage garnishment, which always surprises me. And I don't believe Florida has it. So you're going to have to look specifically. I mean, it's something someone could Google, really quickly, what's wage garnishment in Utah or what is it in California? The percentage will be there, but that's based on state law and that'll vary from state to state.
So wage garnishment laws vary by state. We actually have a guide for all 50 states on wage garnishment laws on our Solo Suit blog. But I think you're right. In my experience, and I'm no attorney, but in my experience doing research in this, 25% is like the highest amount usually that can be taken. What are ways to stop, prevent, or reverse wage garnishment?
I always say garnishment is kind of the gateway into bankruptcy, truthfully. It's tough. When you're trying to resolve these things, I always look at it, from the very beginning, you're trying to create as much leverage as you can to be able to get either a settlement or get the case dismissed. By the time it gets to wage garnishment, there's either been a default judgment or they've gone to trial or there's been a motion for summary judgment that's been granted. The creditor has a judgment. It's no longer a level playing field at all. Most things are in their favor at that point. And then when they get the garnishment, it's tough because even if you're reaching out saying, hey, I'll just try to settle this out, they can tell you to pound sand because they're going to look, we're not going to settle because we're going to get 10% or 15 or 25% of your pay every 2 weeks, whether you like it or not. And the only ways to stop the wage garnishment, in most jurisdictions, there is a hardship as far as, like in Arizona, that they'll reduce the amount that's taken. Even in Arizona, they don't allow it to go away completely, but they'll reduce it. So you can ask the court to reduce the percentage that's being taken. In most states, there's a hardship provision where you then have to come in and show that it's a hardship, which most people can do. Having a quarter of your paycheck taken is a pretty big deal. A bankruptcy filing will stop it immediately, regardless of whether it's a Chapter 7 or Chapter 13 bankruptcy. The moment you file the initial bankruptcy petition with the court puts an order called the automatic stay in place. It stops all collections, phone calls, letters, wage garnishment, everything will stop. Once it gets to that point, it's very difficult to do settlement. I mean, it does happen, but you're probably gonna have to come in with a big lump sum, not some type of payment plan. They've already got a forced payment plan through the garnishment on you. And so unless there was a problem with the judgment itself and you can unwind that somehow, sometimes a motion to vacate, but often I can tell you when people get hit with a garnishment, it usually ends up bankruptcy or just paying off the the garnishment over time.
Gotcha. You mentioned a motion to vacate. I think it's also called a motion to set aside in some states. And basically that's just a motion where you ask the court to reverse the default judgment, right? But you have to prove that you maybe never knew about the lawsuit in the first place and you never got a chance to respond, right?
Yeah, there's got to be a legal basis to do so. And I can say in most jurisdictions, if you weren't served appropriately, that is a defense, and that's a legal basis to get the motion to file a motion to vacate or motion to set aside that default judgment. Where you're coming in and you're saying, look, I didn't get served. You have to have more than that. It has to be more than just you saying, hey, it didn't happen. You have to be able to establish. And it gets pretty tricky because you're kind of trying to prove a negative. You're trying to prove that something didn't happen, which is difficult. But one time I had a case where a client came in and said, look, they have this default judgment against me, and it was a big one. It was like a $35,000 judgment. And they were saying, we went and got the certificate of service, which is the document that the process server has to submit to the court showing what date they brought it by, where they brought it by. And they were saying, I looked at this certificate of service and I know they didn't serve me because I wasn't in Arizona. I was in Wisconsin at a wedding. And I said, well, let's start piecing together, what evidence do you have? And we were able to show, we even actually brought in our Facebook page from in court and showed the judge, look, here's some photos, here's some posts that were made that were time-stamped, hotels, receipts, that kind of thing. And then we were able to get the judgment set aside. The one thing to know with the motion to vacate, motion to set aside, it makes the judgment go away, but it doesn't make the lawsuit go away. It just rewinds it back to the beginning and allows you to, assert your defenses. But what it does do is it puts you in a better position to negotiate. If you're trying to settle, you're going to get a much better settlement without a judgment than they have a judgment already.
Awesome. Thanks for the example too. We talk about this all day long, but I always wish I could see more concrete examples of how it applies in court. So it sounds like you used someone's Facebook profile to prove that they were never properly served. Hopefully they were able to get that settled in the end.
Yeah.
I wanted to know if you truly can be judgment proof in the sense that your wages are not garnishable and you don't have any assets that could be seized to cover the costs that are outlined in the judgment. Is judgment proof really a thing? And with that, what wages are protected from wage garnishment?
Yeah, no, that's a good question. When I meet with people, it's rare someone's truly judgment proof. They may be judgment proof today, but I always ask, what's it going to look like down the road? If someone comes to me and they're 85 years old, they don't have any real estate, their only income is Social Security, and that situation is not going to change, they may be judgment proof. But I have people sometimes who will come to me and say, look, I'm unemployed, I don't own any real estate, but I'm 26 years old. And so they're like, oh, I'm not going to contest this lawsuit, I'm not going to fight it. I'm like, well, yeah, if they have a judgment today, they can't garnish you, but you're probably going to have a job or something some point in your life. And like I said, in most states, they're like Arizona, where the judgments can be renewed. There's no statute of limitations usually on post-judgment. Once the judgment's entered, it has to be renewed. But like in Arizona, they can renew it every 10 years for the rest of your life. And so you may be judgment now, but you won't be judgment, 5 years from now, judgment proof. And then they're able to try to collect on it at that point. So that's what you got to be careful of. There are certain types of income that are exempt. Social Security, disability, Social Security, retirement. Those are exempt under federal and state law. They can't be garnished. They can't even be seized in a bank account. Those are the types of incomes. Military, like VA disability benefits, those are protected in most circumstances. Those are the types of things where we start to look, okay, are there other assets that, they could go after? Real estate's one. If they get a judgment in most jurisdictions, they can record it, and then it acts as a lien against that property. So if it's sold or refinanced, they're going to get paid at that point. So judgment proof it's out there, but to me it's rare. I always say failing to take action is 99% of the cases is the worst thing you can do. It'll just get much, much worse. It's rare when I tell people, yeah, probably you don't need to worry about this, because it seems like the second you think that, it comes back to bite you in the end.
So it sounds like you really can truly only be judgment proof if you do not have any assets and you have no income and you never plan to have any assets or income ever again, basically.
Yeah. And that's what I'm saying. The amount of people that all of those categories applies to is very, very small.
We have a tool at Solo Suit called Solo Settle. It's basically a software that can help people get the settlement conversation started. So if they've been sued for a debt, they can use Solo Settle to send an offer to settle their debt to the junk debt buyer or creditor or debt collector, whoever it is. And it just gets that conversation started, like I said. So I wanted to ask you, in your experience as an attorney, what do you think is the best thing to say to junk debt buyers, debt collectors, creditors, to get them to settle? What kind of language would you use to negotiate a debt settlement?
One of the first things people jump to that I think is actually not as effective is threatening bankruptcy. It's kind of a cry wolf thing. Everybody threatens bankruptcy. It's built into their numbers. They understand that a certain percentage of these cases are going to file for bankruptcy. And often when you tell them, I'm going to file bankruptcy, you're going to get a response of, okay, go ahead and do it. And so I don't think that that's effective. To me, when you're trying to settle with a creditor, and when I help people do debt settlement, when someone has a judgment or something, I view my job is to actually help the attorney on the other side or the creditor sell whatever I'm trying to propose to whoever has to be the decision maker. You've got to paint a picture of, look, here's what I'm proposing, and it doesn't get any better than this. You've got to give them some reasons to be able to accept your offer. And this is particularly true if they already have the judgment, because they have a leg up on you. But if it's something where it's pre-lawsuit or just something, you need to be able to show them hardship. You need to be able to let them know, like, if you are judgment proof right now, or like if I have someone come in and they're on Social Security, that's one of the first things I tell the creditor. Look, they're on Social Security. Code for you're not going to be able to garnish them. If you already have a wage garnishment, if you have other creditors or other lawsuits, I always say, put it out there. Let them know that, look, you're not the only one. There's a line of people trying to come after me here. That also does tell them that there's a bunch of lawsuits or a bunch of creditors, that bankruptcy might be a realistic thing there because you're dealing with a lot of different fronts. If you have tax debt or tax liens, I often will bring those up because those will trump their ability to try to garnish you. Government makes the rules, they're rules that they come first. If you have back child support, back alimony, those are the types of things that I bring up. Those are the factual situations that are telling the creditor, and particularly if they have an attorney, this is going to be a tough one to try to collect on. We better just get something in place. And also knowing that no matter what you offer, you could offer 98% and they're going to come back at 99. They're always going to counter you no matter what you do. So to be prepared for that. And you also have to kind of walk this fine line of proposing something that's high enough that it's just not ridiculous. If you owe a $10,000 debt, if you come in at $200, the answer is no. They're not even going to take it to their client usually. I mean, that's a no. You need to understand that there's going to be some give and take here, but you need, again, to paint a picture. It's not so much the dollar amount, it's everything else around it that helps them to understand that, look, they're going to take it to their client, say, you're not going to collect on this one. This is probably a good deal, or let's come back with this and maybe we'll get something in place. So those are the kinds of things I look for when I'm helping people settle, is why is it? What are the factual situations in this person's life that are going to lead this creditor to say, okay, we'll take less.
You talked about negotiating with someone and then them going back to their client. There's a lot of different layers in this sphere of debt settlement and debt lawsuits. And I just want to make sure our viewers understand the process and how it works. So typically there could be a lot of levels. A creditor is the original lender or credit issuer, right? Debt collector could have taken on the case or the account to try to recover the funds that were lent or borrowed. And then when it escalates to legal action, often debt law firms will come in and they're the attorneys that file the case. There could be a creditor, there could be a debt collector, and then there could be the debt collection law firm. And usually you're negotiating with the law firm, right? And they go back to their client, which would be the debt collector or the creditor, depending on who is suing, right? But it's the debt law firm that you're negotiating with. So you're negotiating with attorneys essentially, right?
If it's gotten to the point of litigation, then yes. And I do have people ask me all the time, like, well, I don't want to talk to the lawyers. I'm just going to call the original creditor. They're just going to refer you back to the attorney. In the first 6 months we talked about that time frame when the first payment is missed up to that 180 days, that 6 months before charge off, you're likely going to be dealing with in-house collection people at the credit card company. Sometimes they'll farm it out to a collection agency. They're not selling it to the collection agency. This is just a hired gun out there who's trying to negotiate it. So they'll probably and they usually have some preset settlement authority they're going to be able to work with. Once it gets sold, sometimes you'll deal with the internal collection people for the junk debt buyer. But, if they have an attorney involved, they are going to have to take it and go back and get approval for it. So it can take some time. There's kind of some back and forth with this. So those are the kinds of things to be aware of. A lot of people misunderstand too. They think that usually the lawyers that they bought the debt. I don't see that a lot. I mean, some firms do, but for most of the time, the lawyers, they're just attorneys. They're just representing the creditor or the junk debt buyer, and they don't have any actual ownership interest in the debt. They've got to take it back and get approval for that settlement.
Okay, cool. Yeah, there's just a lot of players there and it gets kind of confusing. So I wanted to make sure our viewers understood that. So next question about settlement is, in your experience, how much are collectors willing to accept usually? You mentioned, if you owe a $10,000 debt, you can't come in and ask if they'll accept $200 because that's just not realistic. What is a realistic offer? And I know that a lot of factors play into this, like your income, if you're experiencing disability or other, financial hardships, whatever it is. But in your experience, what do you think is a realistic settlement offer?
Yeah, I mean, it's a good question. And it does vary so much depending on the facts of each person's situation. I do, again, break it into two groups: junk debt buyer versus the original creditor still has it. Junk debt buyer, to me, a low settlement is 10%. More typical is somewhere between 30 and 40% of the total amount. And that's often if you're able to do it in a lump sum within like 30 days of them agreeing to it. Generally, you're going to get a better deal with a lump sum. Although I can tell you over the last several years, I've seen particularly the large debt buyers that deal in gigantic volume, they have been more willing to say, no, we'll just take a monthly payment and we'll stretch this thing out over 3 years kind of thing. I think they're kind of playing the long game there a bit with it, thinking that they deal in enough volume that they have payments coming in. But if you're able to do a lump sum in general, you're going to get a better deal. I think with a junk debt buyer, like I said, 10 to 35% is not a bad settlement. Original creditors, it's going to be higher. You're probably going to be somewhere closer to 50 to 75% of the total balance is probably more realistic in a lump sum. And with any of these, if you want a payment plan over time, you're going to usually end up paying more. But there are some original creditors. I can tell you American Express is one that I deal with a lot. And I've been surprised at how far they stretch these things out. I had a really large credit card the other day that settled, but it was a 72-month payment plan. So it's something where it's possible, and part of all this is you're putting it together. I always tell people, you need to come up with, before you reach out to them, you come up with a plan and a proposal of something that's realistic for your budget. You don't want to propose something that's just not going to happen, or even a payment plan where you're proposing $300 a month and there's no way you can pay more than $150. Come up with something that works for your situation and then go to the creditor with at least your initial offer. Don't wait around for them to offer it, because their initial offer is always, we'll take 100% kind of thing.
Cool. I think I just have two other questions. I know we're already past our time, so hopefully I'm not keeping you from going home or anything. But my other question was, do you have any examples of a recent settlement that you came to in your firm? I know this is like private information, but could you just like take away any names and stuff and tell us like a real example of a recent settlement you've come to?
Yeah, I mean, we did one that we got notice on just the other day. It was a junk debt buyer. The total amount of the lawsuit, they had filed suit, and it was about $6,500, and we ended up selling that one.
Can you tell us who the debt collector was?
I believe it was LBNB funding. Yeah. So an LBNB,
you're saying for $6,500?
Correct.
Okay.
And that one ended up settling for a $1,500 lump sum, payable within 30 days of them agreeing to it. So they agreed to dismiss the lawsuit, and they took the $1,500. So there's some factors in there with that client's ability to pay that influenced that one tremendously. Just about a month ago, we did one with American Express where the credit account was very high. It was a $200,000 plus credit card, and that one they allowed payments on. I think we ended up saving that client a little over $100,000, and they broke it up in over 72 payments. So again, the underlying facts do matter. Just, throwing out numbers to these creditors is not going to get you very far. But if you give it some thought of, maybe put yourself into their shoes of how easy is this going to be to collect, knowing that most of the debt collection lawyers, debt collectors, a lot of them are working on contingencies, meaning they don't get paid until they get some money. So they want to do as little work as possible and get as much as possible back. If you're showing them, look, there's a lot of roadblocks in their way to collecting this money, you're going to get a better deal overall.
Wow, that's awesome. So you guys saved, in the one case, LVNV funding $6,500 credit card debt, you settled for $1,500, you said?
Yeah.
That's really good. And then in the other American Express case, you said you ended up saving them $100,000. What were the underlying factors that I guess played into those settlements? Can you share a little bit about that?
The one with the $1,500 settlement, the income was quite low, and we were able to show them it's not going to change. Client was elderly, late 60s kind of thing, and the job situation wasn't going to change. There was no real estate that they could lien. The prospects for collection on that one were low. With the American Express one, there was more than sufficient. There was income there. The tricky thing is with particularly large lawsuits and large debts, I always say it's surprising to me, at least early on in my career, I would see lawsuits for $500, things where you're like, this is ridiculous. But then I would also see a credit card for $60,000 that they didn't file suit on. And the more I thought about it, and the more I even talked to some of the debt collection attorneys, if someone gets hit with a lawsuit for $65,000, the chances of bankruptcy are very high. And they know that. If someone gets sued for $5,000, most people don't file bankruptcy over a $5,000 lawsuit. So they know that their collection rate and the less likely to deal with the bankruptcy issue with those higher ones. So if you see the bigger lawsuits, and you should know this too, particularly the larger debt buyers, there was an article about Encore Capital in the Wall Street Journal a number of years ago. The sophistication they have as far as knowledge they know about you before they even get involved is high. They have a lot of information, and they work with the credit reporting agencies. We often view, Equifax, TransUnion, Experian as kind of these quasi-governmental groups. They're not. They're private companies, and they sell your information to debt collectors. And they even have things called trigger reports where the debt buyer will pay them a certain amount of money. And then when there's some change in your credit report that they have shown leads a creditor to believe that there's a more high likelihood that they're going to be able to collect, they let Encore Capital know, hey, now's a good time. I always get people who say, this lawsuit came at the worst imaginable time. And I'm like, it's not a coincidence. They saw that you just bought a house, or they saw that you've been looking to buy a house, or you just bought a car. They saw that there's been a change of address or a change of job. And so they get that information. So when they're coming to settlement, I guess that's maybe one other point we can bring up. Don't misrepresent your situation, because they often know it. I've had clients tell me before, oh yeah, no real estate, and I'm unemployed or whatever. And then I do a quick search. I'm like, no, even I can see you have a rental property and a home, and if you do that, it reduces the credibility. That being said, you don't need to give them your banking information or who your employer is and all that kind of stuff. But if there's things that are readily available on the internet, like real property records, they're going to know about that. So all of that goes into, them deciding to file suit on a great big claim like that American Express one, and it will influence their ability to, what they're going to take for it. So all those factors go into it.
Awesome. Well, thank you so much, John, for taking the time to meet with me. I think that a lot of the information you shared is going to be super useful to our viewers. Do you have any final thoughts on anything related to debt litigation or bankruptcy, anything at all?
Taking action. That's the biggest thing is don't, so many people just sit back and like, if I ignore this, it'll go away. It's not going to go away, and it will get immensely worse. In almost every situation. So, and that's why I know we've done a lot of stuff with Solo Suit, and I recommend people go there even just for the answer. Get the answer filed. Filing an answer to a debt collection lawsuit can buy you months of time to negotiate, to look and see what defenses you have, to get additional documents from the creditor. Just that one step that 95% of people don't take will change things incredibly in trying to get this thing resolved and help you to avoid all the horrible things that lead to bankruptcy, like wage garnishment and bank levy and all that kind of stuff.
Awesome. Well, thank you for those final thoughts. And again, thanks so much for joining. I'm excited to share this with our viewers. And yeah, I just really appreciate you taking the time.
Yeah, no problem at all. I appreciate the opportunity.
Thanks everybody for watching. I hope you found some answers to your questions. And if you feel like you need more help, head over to solosuit.com. We have a blog with lots of resources that can get you more answers to more questions. On top of that, we have products that can help you respond to debt collection lawsuits and settle your debt outside of court. So if the thought of representing yourself in a debt collection lawsuit intimidates you, or if negotiating a settlement seems scary, go over to solosuit.com. We can help you respond to a debt collection lawsuit, settle your debt outside of court, and empower you to represent yourself in resolving your debts for good. Thanks so much for watching, and good luck with resolving your debts. Solo Suit is rooting for you.